Offenders who have...
The Honourable Phil Goff.
Chairman, I'm still waiting for the Minister of Justice to take the call on the inadequacy of the bracelets, because we need to know that before we legislate for the extension of their use, that they are fit for purpose and not readily removed. Now, we have the Committee of the Whole, so the Minister can hear the concerns, the genuine concerns of the opposition, and respond to them. So I really do hope that the Minister will take the call, because otherwise we are going through the motions and the government's just bulldozing the bill through. This bill's going through with our support. We're seeking for reassurance that the intent of the bill will be carried into practice, because the things will work. But I have another series of questions for the Minister, and it's appropriate that she is the Minister of Justice, because what we have found when we are making these changes is that her colleague, the Attorney-General, has issued a report under the Bill of Rights, and that report, and I want to quote from that report, Mr Chairman, it applies to each of the clauses in this bill that we're working through. The Attorney-General, Mr Chris Finlayson, has said he has concluded that the bill appears to limit freedom of movement and the rights against unreasonable search and seizure and double jeopardy affirmed in the Bill of Rights Act. And he says, sir, that this cannot be demonstrably justified in a free and democratic society. Now, normally I would be deeply concerned at a report under the Bill of Rights that said that we were in breach of the Bill of Rights. But frankly, I think the Attorney-General's report is a nonsense in these circumstances, sir. And I want to be reassured by the Minister about why a member of Cabinet would issue a report like this that actually effectively says we should not pass this bill before the House today. That's exactly what it does, Mr. The Attorney-General is wrong in the judgment that he's giving, or the law is an ass. And I want to go through this with the Minister of Justice. She's well qualified to answer my concerns here. Now, it says it breaches the freedom of movement. Well, exactly, Mr Chairman. Why do you put an electronic bracelet on a person that has been guilty of domestic violence, if not to stop that person having freedom of movement to go to where the victim is and re-victimise that person? So why is it that we are so deeply offended that the bill does what it's intended to do, which is to restrict the freedom of movement? I mean, there's another category of offenders. These are offenders who offend under the influence of alcohol or drugs. And clearly, a condition of their release may be that they do not use or go to places where they can get alcohol and drugs. So, of course, Minister, wouldn't you want to restrain freedom of movement so that you can enforce a prohibition on that person going back to the substances that led them to offend in the first place? And there's another category of offender that my colleague Sue Williams-Seo talked about, and these are child sex offenders. So one of the conditions that you place on such a person is that they don't go to a children's playground or a school. But the Attorney-General is telling us that this breaches freedom of movement. Well, that's exactly why we're passing this legislation today, because we don't believe that a child sex offender should have the freedom to go to a place where that person is tempted to re-offend and re-victimise. So I'm asking the Minister of Justice why it is that we are told by a member of government that this breaches the Bill of Rights on freedom of movement. If it does, isn't it time, Minister, that we change the Bill of Rights to accommodate what is demonstrably justified in these circumstances? And then there's the question of search and seizure. Now, if you go through the clauses of this bill, Mr Chairman, you will see that one of the purposes of each of these clauses is so that we can gather evidence in the event that an offender on parole or home detention or in some other form of restricted movement you're able to get evidence about the offences that they've committed. But then the Attorney-General tells us, no, it breaches search and seizure because we're using the evidence that that person has offended. Now, Mr Bishop, doesn't that sound to you like a nonsense as well? And then there's the third thing, sir. It says that if we pass this, we are breaching double jeopardy, because we are punishing the offender again. Now, I want to put it to the Minister, Mr Chairman, I want to put it to the Minister that this is not at all a breach of double jeopardy. Double jeopardy is when you are punishing a person twice. I passed the original extended supervision order legislation. It was not to punish people twice, sir. It was because the people that the court was ordering that there should be extended supervision over the offender was saying that they were at risk of reoffending. So this is a preventive measure, Mr Chairman, a preventive measure designed to stop people from reoffending. We know that the actual criteria set out under the extended supervision order is that it will be imposed on those that are at risk of reoffending again. So the three grounds that the Attorney-General has given us on advice from his ministry don't stack up, don't hold water. So why, sir, and this is not the first time this has happened in regard to extended supervision orders, but why are we going through the farce of having laid on the table of this House a Bill of Rights vet that patently cannot be right in terms of saying that what we are doing tonight is demonstrably unjustified? Okay, what I want, Mr Bishop, from the Minister is an explanation of why we are yet once again going through the farce of having a Bill of Rights vet that says we should not be doing what we are doing, when I believe that it is demonstrably justified that we do this to protect the safety of the community. So is it too much, Mr Chairman, to ask the Minister to take a call and give the House an explanation of why we have this report laid on the table of the House by the Attorney-General that says effectively we should not be doing this as a breach of the Bill of Rights, when there are demonstrable reasons why we should, and that we are not ignoring the rights of the offender as much as we are enforcing the rights of innocent people not to be victimised in a situation of genuine risk. Now, how many times will we go through this process again where we go through the motions, the Attorney-General says this is all bad, it's not justified, it restricts people in an unfair way, when we are passing this legislation because we do not believe that that is the case? So I've got two sets of questions, just so the Minister hasn't forgotten them. One, if we pass this legislation, don't we need the legislation to work? Don't we need to have assurances, the public to have assurances, that somebody doesn't just snip the bracelet off and walk away? You know, I heard Todd Barclay saying, oh, it's only happened 40 times. Only happened 40 times. 15,000 times the electronic monitoring rules have been breached. Some of them minor, some of them serious. 26 to 40 people out in the community creating some risk to New Zealanders because we have them under electronic supervision, so we know where they are and what they're doing. They've taken it off. We don't know where they are. We don't know what they are doing, and sometimes they do appalling things while they're in that situation. So there is that set of questions. We want this legislation to work and work properly to enhance the safety of New Zealanders, to stop New Zealanders being victimised. And we want an answer on why we lay a Bill of Rights vet on the table that the government apparently, because it's continuing with this legislation, intends to ignore and dismisses as being irrelevant. Well, if it's irrelevant, we shouldn't just ignore it. We should change the provisions in the Bill of Rights so that they make sense, so that when we restrict the rights of offenders in order to protect the right of other New Zealanders, that can be regarded as a justifiable act. They are genuine questions, Minister. I would very much like you to take a call and explain the government's position to the House.
Chris Bishop.
Move that the question be now put.
I'm going to hear.